for example, you're going to sell me your car for $5,000. You accidentally write 500.
Are you
I know that you accidentally wrote 500. You meant 5,000, but I go to court and say, hey, he has to sell me this car for $500.
Welcome back to Under Oath.
Okay, here we go. Another likely fake story going around TikTok talks about a woman who signed her prenup agreement with Disappearing Ink and got a large divorce settlement because of it. What would you do if you were representing this woman for fraud? Jeff, what would you do?
I would sue my attorney immediately. Because if my attorney didn't realize that there was no signature on it, Disappearing Ink doesn't happen.
No, you're representing the woman. The woman. You're representing the woman. She signed a prenup.
Why do I have to do that?
But she signed it in Disappearing Ink.
First off, nobody's responsible for that. See, this is the problem with the internet.
This takes it, though. It takes it a couple of steps, though, because whether or not an agreement was reached. So let's start with that. Was an agreement reached if she was signed with Disappearing Ink? Does the fact that she signed with Disappearing Ink mean anything?
Yes.
Can you still have an agreement even though there's not a signature?
No, prenups are required to be in writing. Now, here's where you get here. Miss Sneaky with her end.
Well, you're representing her, so be careful how you.
God, why do I got to represent her?
I'm reading the question. I'm reading the question.
All right. Here's the deal. In Florida, God, I could really have nothing, but I'm stretching. I say, Your Honor. Okay, here's what I'm going to say.
Is a prenup one of those things that falls under the statute of frauds? Can you explain to the jury what a statute of frauds is, Jeff? I guess
Are you talking about a signing? Or are you talking about committing fraud?
There's some instruments that won't be enforced, some agreements that won't be enforced.
Unless they're in writing.
So
yes. There was a writing, and guess what? Here
is a prenup.
So you put me in a bad situation because there is a writing. And what I'm going to argue is my client never signed it.
All right. So if I'm representing the husband, I'm saying, yes, your client did.
Never signed it.
In that she made representations and the appearance as though she was
How do you know that?
Acquiescing to those terms.
Prove that my client signed.
Because she signed it in front of my client.
He's lying.
We'll let a jury figure that one out.
Go ahead.
Okay.
You're going to put a document out there, and you're going to try to convince a jury. She's going to say, I didn't do it. She did it. Here's a document, but she signed with invisible ink.
But my guy's going to testify that he wouldn't have.
Watch this. Hold on. Did you take it back to your lawyer?
He wouldn't have married her.
Did you take it back to your lawyer? You show your lawyer? Who prepared it for you?
Oh, you're talking about the husband now?
Yeah. Who prepared it for you?
Well, I don't know. Who cares who prepared it?
It's a big deal. Because if a lawyer was involved...
Why does that matter who prepared it?
If a lawyer's involved, the document goes back to the attorney. And the attorney somehow didn't notice that there was no signature?
No. It had Disappearing Ink on it.
Oh. And
it just hadn't disappeared yet.
Oh, yeah?
How do we know the length of time for the... Maybe it takes a month.
Why are you assuming that there's Disappearing Ink?
It takes a month to disappear.
Prove that there was Disappearing Ink.
I saw her sign it.
Oh, well, she's saying she didn't.
Oh, then that's a jury question.
Okay.
You're comfortable.
But
you're
the fact
comfortable
is this, if a writing is required,
you're comfortable taking your hussy of a client.
You're damn right.
To court.
You're damn right.
And letting a jury decide whether.
As a family lawyer who relies on,
paid by the hour,
gets paid by the hour, whose Lexus payment just popped up because you set another hearing. Good for me.
So you
why we don't do family law.
You'd be happy to yes, and this right here is why we don't do family law. We
don't do it because
there's no winners.
There's no win. You know who's
win.
winning? The attorneys. The fact is this. It's your job to make sure that the signature is right. But your signature actually doesn't even require a signature. It could just be an X. It could be just the symbol of your name.
I actually saw that one of the ways that experts determine that a handwriting is forged is that it matches perfectly to the millimeter other signatures, because it has to be a copy.
Well, it could be others.
It
has to be one.
You cannot sign your own name the exact same way every single time.
What I'm saying is this.
Mathematically. Like if you measured
all
of the signature lines mathematically.
Now, when we talk about deceit, in law, we deal with that all the time. And you just discovered what I did was what happens during a case all the time. It is absolutely not unusual for somebody to lie. Craig and I had a trial about a couple months ago. We were in Tennessee, and the person on the stand, we had already deposed them, which means that earlier beforehand, we were able to ask them questions, and it was printed out, and we put it in front of them. This person lied at least 20, 30 times. People lie. They lie in court for money. They lie for their freedom. They lie for everything. So in a situation like this, I would need to prove my client, of course, would lie and say she never signed it. She would never go, well, I signed in disappearing ink. That's why you can't see it. That would never have been said. Her lie would be like this, and I want you to know this is how it would play out. She'd go, well, I was at the thing. I was thinking about signing. I had the pen in my hand, and I didn't. And I just pushed it back towards him. Now, you would have to say, hey, somebody saw her sign it. I don't know what happened. Well, that's your job to prove why that signature isn't on there. And that's why immediately I would go, hey, listen, I'd have to get it tested. But here's where it gets screwy. Most likely they're bringing a copy in. So you won't have the, how can I put it, the chemicals, the material that they used as the ink that went away. But you would have it.
You wouldn't have the original document. Yeah. You can tell from the original document.
And here's the issue. A lot of attorneys don't think like that.
What if you had like the weirdestly honest client you ever met? And she said,
I call that Tuesday.
She said, no, I just made it look like I signed it, but I had no intention of actually signing it.
Here's the thing. When it comes to autographs and signatures and everything else you're trying to, it's not my job to go in your head to figure this out. And
but
that's
if
what
she's
the court
going
will find.
to, if she's going to get
I
the
meant
benefits,
to deceive him.
Right. So if she says, I knew that he wouldn't marry me unless I signed this document, but I didn't sign it. I just made it look like I signed it because I wanted to fool him into marrying me. Did she, with those facts, is she going to be held to the terms of the prenup that she didn't sign?
I think her intentions in this case are irrelevant. I did it to fool him. It's kind of like what was the issue we talked about?
It's like promissory estoppel, right?
Yes.
You've now changed your position. You can't go back. And the only reason you changed your position is I made you believe something about the world.
Right.
Either something about what I was going to do or give you. If that's the case, then shouldn't she be held to the terms of that?
What is the basic contract law where one person knows that something is wrong in an item and knows the other person doesn't know?
A unilateral mistake. When you discover a unilateral mistake from the other side, but you take advantage of it. For example, you're going to sell me your car for $5,000. You accidentally write 500.
Are you
I know that you accidentally wrote 500. You meant 5,000, but I go to court and say, hey, he has to sell me this car for $500 because I got it right here in writing.
Well, that also applies the other way. That applies to your earlier argument that I knew it was wrong. You can flip that.
Right.
And I knew you were relying on this.
Yeah, that was my point.
There you go. So when it comes down to it, whatever tricky stuff I do that I'm intending to deceive you on when it comes to a contract, if I slide something in or I put something in a way that I know you're interpreting it differently, all I have to do is prove that if I'm the one being deceived, I just have to prove that that was your intent. And in this case,
you intended to deceive me.
You admitted it.
So you should be held to the terms that you deceived me. You made me believe you were agreeing to them, even though you didn't.
And just so you know, I'm going to give you a little law, even though I don't do family law. Prenup agreements cannot be signed under duress. For example, let's say on the day of the wedding, you go, I'm not marrying you unless you sign this. It's not going to be enforceable. Now, if I say to you 6 months beforehand, if you don't sign this, we're not getting married, I can do that. But I can't do that in a situation like that. Because a person is under duress. They've got other things that they're dealing with. You're already down that road. You're in a position where you can't argue or fight because
my mother's coming. My
mother's coming. The point is this: they realize that a person is not in their right mind, and they shouldn't have the ability. Well, they shouldn't have the ability to contract on the day of the wedding.
I don't think that's the position to take. That the person who's getting married isn't in their right mind to make decisions. It's case law. That's going to affect the rest of their life.
It's already been determined. I don't have to tell you why. It's in the books. That's the greatest thing. It's a book.
Duress is if I point a gun at you and say, I'm going to kill you.
This is the example they use when they talk about
I think we're
prenups.
just arguing about whether or not that constitutes duress.
It is.
I will agree that duress invalidates your signature, but I don't think saying on the day of wedding, I'm not marrying you is duress. Duress is literally, I've got a gun to your head.
See what I'm going to do to you?
I don't know. What are you doing to me?
Remember the Fourth Estate?
How do you know this question?
Because I've been asked it on almost every bar I've taken. that deals with prenups.
Yeah,
It always comes up under the same thing. On the day of the wedding, you cannot be
Oh,
forced
I
to
don't
sign.
believe that. I think you're
Watch this.
you're making that up. You're making that up to win the debate. You know I can't prove you wrong right now.
Watch this. Yeah, you can. You know how I'm gonna
I
prove you
can't
wrong?
go to your bar
Watch this.
exams and pull
Watch this.
off that exact question.
During our break, and when you go back there, because I know you're going to do it,
I'm not
because
gonna
you
do it.
need to prove me wrong.
I'm right.
You need it.
I already am right. I don't need to prove myself
Okay,
right.
Franklin?
Sure. You have to prove it, though.
No, I don't.
Yeah.
No, you have to prove me wrong.
No, you're the one making the affirmative
No, I don't want
statement.
you to argue and go.
It's not automatic duress.
What I'm saying is,
It's not automatic duress. She doesn't have to, or he doesn't have to go through with the wedding. They can bail out right then.
There are at least
Hey, I'm going to kill your mom
there
if
at
you
least-
don't sign this. Okay,
there
that's
are
different.
at least 10 family lawyers who hate us for disparaging their way of living, who will come to you and go, Mr. Lynd,
Yeah.